Yes, Mr. Rowe.
Thank you, my Lord. So to conclude, I hope relatively briefly, with our submission.
You didn't give an undertaking, so...
I didn't give an undertaking, that's true. But I think I'd be reasonably safe even if I had.
Yes.
To conclude our submissions, I think more or less dealt with, to the extent I can, with the point about the judge's approach to the factual issues before her, and your Lordship and your Lordship will no doubt want to look again at the detail of the evidence that had been placed before the judge in due course. I do respectfully stand with the submission that the judge was entitled to take the approach that she took on the evidence, though I accept that she didn't set out in detail her reasons for doing so. But I'm wrong about that, of course, and if the question arises in this court, then I make the same submissions essentially to this court as to what one should make of the evidence. The only other point I'd want to make briefly about Dr. Cohen's evidence is just to point out, which is perhaps already in the court's mind, but she does say in paragraph 19, page 279, while strictly outside my experience, the problems identified above for remote medical assessments would be equally relevant to any other assessment, including remote legal assessments, which cover much of the same material and would face the same difficulties and limitations, with some people clinically unsuited to and at risk from the process, and the information obtained highly likely to be partial and incomplete. And the difficulty for the judge and for this court, if the judge was or going to, or this court is going to find in the claimant's favour, is that you are presented with expert evidence which doesn't quite hit the point that we're really concerned with. You've got evidence from the claimant's own, either from the claimant in the form of Dr. Losley or the claimant's solicitors, which in my submission shouldn't carry a great deal of weight for that reason. And you've got Dr. Cohen's report, which is a report, but admittedly by somebody who is experienced, but about, albeit as a forensic physician, as she describes it, but essentially about her experience of witnessing psychological, the obtaining of medico-legal psychological evidence, and saying, well, you can extrapolate from that into what it would be like for a lawyer obtaining information. And the point I make about that is that I'm not saying that you should regard that as completely useless or irrelevant, but on the other hand, one has to take into account its context and the fact that what one is trying to do, if one is approaching this question, as a matter of fact, is answer ultimately what's a sort of value judgment type question. Do these difficulties which apply in that context, are they likely to translate into difficulties in this specific context? And if so, do they do so, or are they likely? Is there a real risk that they'll do so in enough cases that one can say that the right of access to justice has been impinged upon unacceptably? Mm-hmm. And in my submission, the answer to that question is no.
Were those submissions that you made to the judge?
I think essentially, my lord, yes.
So you invited the judge to depart from the evidence of the witnesses put forward on behalf of the claimant for the reasons you just elaborated.
Whether I said depart from, I don't know. I invited the judge to make an assessment of the. I mean, I'm answering a lordship's question from memory. I expect if it's important, I can get find out. I'll get in touch with my then junior, assuming his current responsibilities allow him any time to talk to me, and find out in more detail if he's got a note of it. But that's the gist of what I think I said.
Okay.
I'm sure my friend will tell your lordships if he has a remarkably different recollection.
Just as a general point, since it doesn't affect access to justice at all, if anybody else would like to remove their wig, they're very free to do so.
I'm so sorry. My head felt a bit light. Thank you very much.
Well, the court removed theirs some years ago by order of the powers that be, so we're stuck sweltering. So, my lord, that's essentially what I say about that. It's not a question in my submission of. It's not as stark as saying you have to depart from expert evidence. It's a matter of assessing the whole of the evidence in context, bearing in mind the particular distinct question that the court was called upon to address, and that this court is called upon to address if you accept my friend's submission that you should set aside the judge's decision, and if you accept that it's relevant as a matter of law. So that's, I think, all I want to say about that. Your Lordship did mention the case about expert evidence insofar as it's relevant. I found out over the short adjournment that the answer is it is live before the Supreme Court, and it's being argued on the 21st and 22nd of June.
Is that the Griffiths case?
That's the Griffiths case.
Yeah.
So in due course we shall know what the Supreme Court say about that. But for the moment, the decision is the law is plain and settled, that the court is entitled to depart from even clear expert evidence on point, and even if there hasn't been cross-examination of the expert. But without repeating myself unduly, I say we're not quite in that situation here in any event. So I don't need to rely on quite such a stark suggestion. Though, if the matter is at large again before the court, and your Lordship think that's the position we're in, then I would say that. But
just pause there. Do you direct a jury, don't you? They don't have to accept the expert evidence as long as they've got good reason for departing from it.
Yes, expert. I think that's right. Juries are told specifically that expert evidence is no different in quality from anybody else's evidence.
And it's something they don't have to feel they have to accept.
They don't accept it.
Even if it's not challenged.
I think that's right.
I think there's some debate in Griffiths and Tuohy about the analogy you draw between criminal cases, and I think there is a discussion at that point.
Yes,
as I recall it. Although I think it's Lord Justice Bean's dissenting judgment, which is much starker in civil litigation.
Yes, I think he's the learned justice who says essentially he's always understood that you have to cross-examine if you want to challenge.
If you don't put any your own expert evidence in, and you don't cross-examine, you can't just, in closing submissions, hence my last question, put to the judge that they should disregard the evidence which you had the opportunity to counter. You can make submissions as to relevance or weight, but you can't just simply say, if it's on point, that it should be disbelieved if it hasn't been challenged.
Well, it's always
that's the dissenting
yes,
view.
Yes. I mean, one always has to be very careful about what one means, I think, but I would suggest just by departing from expert evidence, because, of course, in the starkest case, if the expert says, I don't know, in my experience, most surgeons do such and such a thing, it would be a very strong thing for the judge to say, I don't believe that. I think they mostly do something different, and there was no basis for it. On the other hand, if it's a debate about the implications of the evidence, or how the evidence bears on the particular issue, or even in one case what the expert's really saying. There's a case that's cited in Tuohy and Griffiths and Tuohy called Woolley in Essex County Council, which I know about only because I think it was my first or second appearance in this court many years ago. But that was all about an unchallenged expert report and what implications could be drawn from what the expert said, and could one, even though on the face of it he was saying one thing, could one go back and look at the report and say he can't have meant that? I think that was a case where the conclusion didn't quite follow from all of the other aspects of the report. And one party said, well, we accept all the other aspects of the report, it's just the conclusion can't be right based on what he says. I think the Court of Appeal's decision was we were entitled to do that. So that illustrates the need, in my submission, for looking quite closely at what the evidence actually is. And I say that in relevance to this case because actually when you look at the agglomeration of material, there is expressed, as the judge put it, a strong preference in certain contexts, indeed it probably said to be essential in certain contexts, to have direct contact, but it doesn't quite touch on the issue that's before the judge and before this court if it requires to be looked at in this court. I've taken the word strong preference from the judge's judgment in the present case, which may have been picking up on that. So I think that leaves only then the question that was raised before the short adjournment, my lord, by Lord Justice Snowden, which was about the question of what do we make of the fact that SPM herself is the appellant, even though the situation was such that in fact she was able relatively quickly to get legal advice and indeed was able to get bail. The answer to that, my lord, we would submit is this. The claimant could have, present appellant could of course have made a more modest claim than the one that she in fact makes. She could have said, I was lawfully detained, but I was not afforded a face-to-face meeting with a lawyer within a relatively short period of time, because the DDAS appointments are relatively frequent. And indeed, I don't think this has been said specifically, but it's in the evidence. One can have more than one. There's not a limit how many you can have. So she could have said, well, I wasn't afforded a face-to-face meeting, and as a consequence of that, I suppose she could have said either that failure itself was unlawful, that was some breach of, either a breach of duty by the Lord Chancellor as the provider of the DDAS scheme, or perhaps a breach, I suppose, possibly a breach of duty by the Home Secretary as the person detaining, that the Home Secretary should have facilitated that in conjunction with the Lord Chancellor. And that, or it could have been said, I suppose, that by virtue of that, at that stage, her detention became unlawful. Well, possibly. Well, that would be a more ambitious claim. But she hasn't chosen to make that rather modest claim. What instead she's chosen to do, of course, at first instance in conjunction with Women for Women Refugees, is to make the much more ambitious, we would respectfully submit, extreme claim that her detention was unlawful ab initio because of the essentially structural point that she makes, under which she says the Secretary of State had no power to detain anybody at Derwentside for all the reasons that we've been debating. And we don't suggest we can stop her from making that claim as a matter of standing. And she was detained. She comes before the court and says my detention was unlawful. Because
from the outset, I think.
From the outset, because there was never any power to detain anybody at that centre. She says other things, of course, which have been put off to another day. She's wrong about that. But that doesn't. There's no standing point that can be taken against her in relation to that. But it does throw into sharp relief the ambition of what it is that she's seeking to do, which is the consequence of the way in which the appellant's claim came to be brought at the same time as the claim by the organisation that was opposed in principle to the detention of women at the centre. What that means in terms of what the court could do if it were persuaded of the correctness of the claim is perhaps a separate issue, and that perhaps takes us to the appellant's note of the relief that's sought. Because as a general practice, I would suggest the court shouldn't do more than it needs to do to give justice in the particular case. And if the court is against us, then all that's necessary is a finding that the detention of the appellant was unlawful. That the lingering effect of the systemic claim by Women for Refugee Women could be seen in the appellant's note of the relief sought, because it obviously seeks to go much wider, detaining women at Derwentside under the circumstances pertaining there between 28th of December 2021 and 1st July 2022 involved, etc. And declaration that detention not of the appellant but of women at Derwentside was ultra vires. And I would respectfully submit that would be to go too far on what is essentially an individual's claim about her false imprisonment, as it's now been formulated.
Do we need to say more than that she does not bring this claim on behalf of other people?
You don't need to say, no, you don't need to say any more than that in the judgment.
To justify, if we were in your favour on remedies, we would effectively be saying, but you lost. We would effectively say we're not going to make a declaration under A or B because she does not purport to represent other people.
Yes.
Is that sufficient?
Is that because it's very fact specific? It's just conceptually quite difficult, isn't it? Because her claim is very systemic in nature. It's not really based on
No.
her own personal circumstances. It's just saying I'm one of a cohort.
Yes. Yes, her claim depends upon the court accepting that detaining anybody at Derwent's side, any woman at Derwent's side, and any of it was women who were detained there, so detaining any of the potential people who could be detained at Derwent's side was unlawful for the whole, for at least the period when she was there.
But she only has an interest in her personal remedy.
Yes.
And does her detention? Do you say her detention? Sorry.
We were just, we might just want to leave it.
I might as well say the judicial whistles. It strikes me that it's potentially quite tricky, this whole issue about disposal. Were we to be against the Secretary of State and in favour of the claimants? And one way of dealing with it, because we might want to just investigate this a bit more, would be just to put that on ice and come back and sort it out if needs be at the end of the day. And I tell you what's in my mind is that the last thing in the world we want to do, if the claimant was to win in this case, is to get her home, say nothing about all the others, and then have a whole slew of other actions coming into the administrative court, I guess probably out of time. But you know what I mean? I just think we need to think about it a bit. But it may not be the right time to do that.
Well, I'm in the court's hands if that's the collective view. I won't say any more about the subject, and we'll
But
put
let's
submissions in later,
see
if it arises.
what any judgment we write comes up with.
But your point is that we can use this point as a means of testing the extent of the claim that we've been addressed on, and whether it structurally works.
Oh yes, that's another. That's certainly another reason for mentioning.
And I was just along those lines. I was just trying to sort of look, for example, at the Declaration D in the note that we've been given this morning, which says the declaration the claimant's detention was unlawful as a result of being detained without effective access to justice, without prejudice to the other points. Now, just pausing there, it's a declaration that the claimant's detention was unlawful. Detention from when to when was unlawful as a result of being detained without effective access to justice. Because as far as the claimant is concerned, you'd say that she was part of the systemic problem. On the assumption we're against you, she would be part of the systemic problem from the moment she got there. But that must have stopped at some point once she has had effective access to justice through surely a route,
Yes.
albeit it's said to be fortuitous. Or,
Yes.
or is it that, I mean, and maybe this is a question for Mr. Goodman, so I'm sort of in a sense saying it to you so that he can think about it.
Yes.
But if her detention was unlawful because she was just one of the cohort when she got there, but she did actually then manage to get a face-to-face meeting with a lawyer, is her detention still unlawful because of the systemic problem, or is that cured, and therefore it would be effectively she was only unlawfully detained whilst she was subject to the systemic problem, but it ended once she got her face-to-face meeting. I mean that's the question.
Yes, on her case, I make this point to illustrate what we say is the rather extraordinary nature of her case. On her case, she was unlawfully detained for the entire time that she was in detention.
Because no one should have been.
Because nobody should. That's right. There was no power. The paragraph 18 power hadn't arisen.
What? But in relation to her?
Well, the logic of her case, if you accept it, is that there was never any power to detain anybody at that centre because there wasn't the provision of the face-to-face advice on a routine basis.
But this again, this point is it goes back to this point about, but she did get face-to-face advice.
Yes, she did. Which I mean, I make this as a merits point really. So it's why the case is very problematic. But certainly, if the court were to decide the case in favour of the appellant, on the basis on which it's been put, this systemic problem which deprives the Secretary of State of any power to detain anyone at Derwent's side, then nevertheless all that's necessary in the relief I'm conscious that you want more thought out submissions about this in due course probably, but it is a declaration in relation to the unlawfulness of the appellant's detention. And one doesn't need to go. It doesn't need to go into it being unlawful as a result of being detained without effective access to justice, as per D, which suggests a finding that she didn't have effective access to justice.
You would say that a case which involves her still being unlawfully detained despite having adequate legal advice is, I'm not quite sure what the technical term is, but it's the 13th stroke of the crazy clock. And you would say it just demonstrates that can't be the right approach.
Demonstrates that actually what the real target of the claim ought to have been is the specifics of the arrangements by which legal advice was provided, not detention itself. My lord, unless there are other things that you think I could usefully deal with that I haven't, that's all I'm going to say.
No, that's very helpful. Thank you very much, Mr. Rowe. Yes, Mr. Goodman.
Yes, my lords, my lady. I'm going to deal with my known friend's so-called sequencing point first. What he says is the non sequitur between there was a breach of access to justice, therefore detention. Then deal with why the Section 27 arguments have no bearing on my argument. Then consider, is there a real risk in the real world of an impediment to the free flow of communication? I'll address the question raised by my Lord Justice Stuart as to whether it makes a difference that the challenge is to arrangements rather than to a rule or prohibition. Then I'll look at anxious scrutiny and then at the remedies issues that were just canvassed just now.
Thank you.
So on the non sequitur argument, the argument for the respondent is that it's a non sequitur to submit that if there is a breach of right of access to justice, then there is a false imprisonment. That's the point I want to address. That alleged non sequitur proceeds from a misunderstanding of the sequence within the appellant's argument. The proper sequence, on a proper understanding of the applicable legal principles, is this. If we go back to Lumber, Lord Dyson, his explanation, which I took the court to yesterday, by reference to the case of the Crown against the Governor of Brixton Prison ex parte Hague, is there are two components to a false imprisonment. The first is the fact of detention, and the second is the lack of authority for that detention. The reason there are two ingredients is that in English law, every detention is regarded as prima facie unlawful. And so in a false imprisonment claim, it falls to the detained person to prove detention, and the burden of proof then falls on the respondent to demonstrate the authority for that detention. So here, detention is not an issue, so the burden falls on the respondent to show what is the power, the authority by which she was empowered to detain the appellant. We have that pleaded by the respondent at paragraph 2 of her skeleton argument before this court, and indeed in the detailed grounds of defence. But if we take paragraph 2, we see the respondent's argument. The power to detain is contained in paragraph 18 of Schedule 2 to the Immigration Act 1971. So that is the authority upon which the respondent relies as rebutting the prima facie unlawfulness of the detention. So the question, therefore, is, in the proper sequence, was the detention within the scope of that asserted authority to detain? The respondent also, we've seen, accepts paragraph 31 of her detailed grounds of defence, which was considered just this morning. The following, I'll take this up. It's 108 in the bundle. 208, sorry, core bundle.
Sorry, I've missed the bundle we're going to.
It's tab 17, page 208 of the core bundle.
Core bundle.
In the present case, the Secretary of State naturally accepts that when Parliament authorised her to detain relevant people in such places as she may direct, Immigration Act 971, Schedule 2, paragraph 18, it did not intend to authorise her to detain them in a place to which lawyers had no access. This is because it is uncontroversial that the ability to communicate with one's lawyer is a civil liberty that Parliament cannot have intended to take away from persons detained under immigration powers. Otherwise, it would have said so explicitly. And that's an important concession, not because it goes far enough to concede what we, the appellant, need, but because what it concedes about the nature of the power that is relied on as authorising the detention. What it is saying is that the principle is, and I say rightly accepted, that the power, though broadly expressed, is subject to the right of access to justice. It accepts that on the premise that the power...
Sorry, I'm going to stick my oar in here right at the start. I don't want to... The expression access to justice needs to be unravelled for me. It's just a label that everybody slaps on. Without explaining exactly what it means. And,
I will do.
I raised that question this morning. So, and you know, it's not grappling with the real question at the moment for me.
I intend to direct my submissions exactly on that point in a moment. But
Okay.
just at a higher level, there's no dispute between us that the scope of the power, whatever access to justice may mean, is capable, and indeed is limited, at least in so far as the respondent says the access to justice right extends, to that extent. So the respondent doesn't say this is a broad power which allows us to detain any location, regardless of the of any interference with the right of access to justice. It's accepted that if its understanding of the scope of right of access to justice is correct, nonetheless the power is still limited to that extent. That's the important first point. So there's nothing wrong with the sequencing that the appellant puts her appeal on the basis of, because the question is there then an interference, as my Lord says, with this right of access to justice? But if there is, it's not in dispute structurally that it is without the scope of the purported authority for detention. And so it would be a false imprisonment on that premise. So the non sequitur argument doesn't succeed for my learned friend. The respondent can only succeed if she can show that, unlike detention in a coal mine, which would fall within the category she concedes would be unlawful, detention at Derwentside was within the ambit of the power in paragraph 18. And for that, she must show that Derwentside did not infringe the common law right of access to justice. So we're all agreed we're here in ex parte Sims per Lord Hoffman and unison per Lord Reid territory as to the principle of legality, and I'll just find the references to that. The Lord Hoffman in Sims is tab 8, page 95, E to G, and the similar principle of legality expressed in unison per Lord Reed is tab 16, page 392, para 88.
You don't want us to go there now, do you?
We've been there already, or we
thought
may. I think the principle is well understood.
There's
So-
nothing in particular you want to highlight there. Given
The
the
principle is that Parliament is presumed to legislate in accordance with and not to derogate from or to authorise the abrogation of fundamental rights, and that's well understood, I hope, within the course of this hearing. So, when we look at the prisoner cases, the same principle is at work when the courts say that the prisoner retains all the civil rights which are not taken away expressly or by necessary implication. So, see, for example, Raymond and Honey, tab 3, page 18 at G to H. And so turning to my lords, or what we therefore have to turn to next is to ask what are the contours of the fundamental right of access to justice relevant to this context. And the test which I submit should be applied is based on Leach. In Leach, combined with unison, in Leach the principle was that the power in section 47 at issue in the Leach case of the prison, the relevant authorising rule for the prison rules, did not authorise the making of a rule which created an impediment to the free flow of communication between a solicitor and client about contemplated legal proceedings. So, just to make sure we are precise about that, we do take up Leach.
but nothing prevented the free flow.
Well, let me come to that, because I understand my Lord's point, which has been made several times about prohibition. I'm coming to that very specifically in reply.
I'll try to stop repeating myself.
That-
It won't work.
So, Leach is at tab 5, and we went to the holding. We see it summarised at E on the summary held. Section 47(1) did not authorise the making of any rule which created an impediment to the free flow of communication between a solicitor and client about contemplated legal proceedings. And that is a summary of what we see at 47 in the bundle. The whole passage A to E is relevant, but it says at E, it follows that the section 47(1) of the Act of 1952 does not authorise the making of any rule which creates an impediment to the free flow of communications between a solicitor and a client about contemplated legal proceedings. So adapting that to the modern formulation of the access to justice test which we have in unison, I submit that the test in this context is whether the arrangements, because we're dealing here with arrangements, in the real world created a real risk of impediment to the free flow of communication between a solicitor and client. In the course of this hearing,
Say that once again. So
yes,
I'm writing it down.
whether the arrangements in the real world created a real risk of impediment to the free flow of communication between a solicitor and client. There's two parts of that. The first is whether there is an impediment to the free flow of communication, and that's the point on which the judge below found against my client. And the second, which has been put in issue a number of times by my Lord Justice Stuart-Smith, is whether it makes a difference that we are here concerned with arrangements rather than a prohibition or written rule. So dealing with that first question, whether there was an impediment to the free flow of communication, my submission, which I can at this stage I hope take succinctly, is that the evidence shows the free flow of communication was impeded by the practical real-world circumstances. Critical to that submission is that the court is here concerned with the fact that at least some of the women detained are vulnerable women to which particular considerations apply. That must be a relevant consideration. It's no use saying that deaf people can only access legal advice by phone. We're well used to reasonable adjustments and the need for different people to be treated differently. It's at the heart of the equality principle. The evidence shows, and showed to the judge, that this particular cohort has particular vulnerabilities. And the evidence shows, in particular, that the free flow of communication between solicitor and client in relation to contemplated legal proceedings may require the disclosure of deeply traumatic and sensitive personal experiences and information by the client. And the evidence shows that for this group of detained women, at least in some cases, the free flow of communication requires rapport and trust, and it requires in-person communication. The effective inhibition of access to in-person communication in the real world therefore creates a real risk of an impediment to the free flow of that communication.
Sorry, when you say, if you just rewind, you're using this in the real world bit.
Yes.
There was nothing that stopped your client from having a face-to-face meeting with her lawyer.
Well, as I've made very clear, my lord, in the real world, I do not accept that to be the case.
Well, it happened. She had a face-to-face meeting.
Not until she was released, following the issue of these proceedings. She never met with a lawyer face-to-face while detained.
She had the appointment when she was down in the south, and then she went back to the north.
She was frustrated by being moved from Colnbrook, where she was about to be put on the aeroplane, because it's near Heathrow, back to Derwentside. It was the very act of putting her in Derwentside which frustrated the ability for her to meet face-to-face.
Well, I mean, was that just an administrative sort of thing that the lawyer would have turned up at the wrong place? I mean, I wasn't aware that there was anything stopping the lawyer following her up to Derwentside.
The evidence shows that the lawyer could not sufficiently fund by legal aid the trip to Derwentside. That's been addressed in submissions extensively. It's in this evidence of Shalini Patel. When she was at Colnbrook, the lawyer arranged to meet her. Great, I can do that. I can get to Heathrow.
But this is where we're getting towards it. So that the real world that prevented it happening was not the location, but was the absence of funding.
No, the evidence, no, because the location, when it changed to Heathrow, makes very clear that that was the difference.
Yes, but the reason the lawyer, I thought you just said, I mean, the evidence is that your interpretation is that when the location for the meeting was changed, it became uneconomic for the lawyer to make the journey.
When the location was changed from Derwentside to Heathrow, the real world change of location meant that there could be a visit arranged. When it was moved to Derwentside, the real world location made that impractical for a lawyer to meet with her.
What regime, forgive me for asking, I should know this, what funding regime were they on by that stage?
The wider form of legal representation.
So that would have covered travel time and travel expenses, provided it was reasonable.
Sorry, I didn't hear that question. Sorry.
Provided it was reasonable. The broader form.
Well, it's addressed in the Ms. Patel witness statement that a speculative applicant, you have to apply retrospectively.
Yes.
Having done the travel, that was the only way, particularly in the urgent circumstances of this.
But so far as the contractual basis upon which the solicitor was working at the time, there was available, or at least in theory available, funding for travel time and travel expenses subject to proof of reasonableness.
I would put it that the possibility wasn't excluded, provided you could satisfy the legal aid agency that this highly exceptional course was necessary, but for the reasons given in Ms. Patel's statement, she didn't expect that to be a likely course of action. So we're just dealing here with one case, but we've seen the statistics that it applied. Realistically, this applied many, many times over. That's what the structural point is about. The individual case is helpful because it shows how it played out in one given case, and in fact the given case is really quite apposite on the difference that the location actually made. But that's not the way the claim is articulated. So the submission I was making is the effective inhibition of access to in-person communications is therefore, because of the submissions I've made about the nature of the cohort, an impediment at risk of impeding the free flow of communication. And for that reason, it's of a kind with what is identified as a matter of principle in Leach. So in Leach, in the circumstances that pertained in the 1980s and 90s, the impediment was because he couldn't correspond, and that was a necessary component of the right to the free flow of communication. The argument for the finding of Lord Kaplan in the Scottish Leach case, that, oh well, if he didn't have correspondence, he could see the solicitor in person in the alternative, so the end result was he could still communicate. That was rejected. So the next question is my Lord Justice Stuart-Smith's question, which really arisen through judicial questioning rather than as a point taken by the respondent, is whether arrangements, practical arrangements rather than a rule, can inhibit that right to the free flow of communication between solicitor and client. In my submission, there's no principled basis for finding otherwise. Principal authority which I would rely on to assist in that submission is FB, which was the Medical Justice FB case, the most recent 2021 Court of Appeal decision. That was the case about a series of arrangements which the Secretary of State for the Home Department had for effecting people's removal. The challenge there was about Section 10, that was the power to remove. Merely says Secretary of State can remove people who don't have leave or require it. The arrangements made in FB were these notice windows, and the Secretary of State wrote this down in a document. But what was really at issue was the arrangement. The fact that it was written down on a piece of paper what would happen isn't of any moment. These arrangements could be written on a piece of paper and say people will only be entitled to remote access at Derwentsside when they're detained there. They could be formulated into a piece of paper which we could challenge as a policy or whatever it might be called. But the substance of FB was that it was a challenge to arrangements, not to a rule or an inhibition or a prohibition of any formal kind. There was no requirement on the Secretary of State to write it down. She did so as a matter of good administration. So if the challenge in FB, if the Secretary of State hadn't written it down in FB and just started removing people in this way, the challenge would have been the same. She just made the arrangements. The challenge would still have been that's an infringement of the right of access to justice, and it's not authorised by Section 10, by the overarching power to remove people. So there's nothing magic in the fact that all the prison cases refer to standing orders and rules, or in the case of unison to statutory instruments. FB is an example of a sufficiently similar kind that the court can take it that arrangements can interfere with access to justice just as much as a rule or inhibition.
You've chosen to use the phrase arrangements, which I'm not sure whether you picked it up from something one of us said or whether it's all your own. In private law terms, the distinction that our questions are probing away at is, I think, the distinction between an act and an omission. What's being got at, I think, by the respondents, is that they have not committed any act which prevents the free flow of communication. On your case, the Lord Chancellor has simply failed to do as much as you say he should have done, or she, whichever, I think it was, they should have done, to ensure that you have a level of communication that you contend for. So I'm not sure, although it's very neat, and it's very elegant, your use of arrangements for FB, I don't think that gets to the nub of the question.
In my submission, it does, my lord. And let me illustrate that again by the oil rig example.
Yeah.
So if Derwent's side was on an oil rig, same Lord Chancellor provision of legal aid, still all in place in the same way. It's still not a prohibition. My instructing solicitor can still get in a boat and row there, but the arrangements are much more starkly what's putting the barrier in the way of her accessing, or in the way of the free flow of communication between solicitor and client. It's the Secretary of State's doing now. It's no different in Derwent's side.
There is a distinction in this way, isn't there? I mean, you're talking about inhibiting the free flow of information. If the information is imparted, there's nothing inhibiting its flow. Your case is that it's just more unlikely to be imparted
Well,
in a remote hearing than face to face. I mean, there's an echo of that in Leach, where it said that if you know that the prison governor is going to be reading your letters, or otherwise, you might be slightly less inclined to communicate frankly with your solicitor.
I agree that's a very helpful echo, because it's a psychological inhibition that's being talked about there, that you feel constrained within that context to be able to be full and frank as one would hope or expect in privileged communications. And what we're dealing with here is a similar psychological inhibition. That's what the evidence tells us about for people who have a need to disclose sensitive and traumatic experiences.
Or at least there's a risk that that is the case.
We're in real risk all the way through. If I omit to every time to repeat that, that's the test I'm articulating, the real risk of that, so that the inhibition is a psychological repression of the ability to communicate, which is attributable to the arrangements made by the Secretary of State.
But it's not quite the same. I mean, it isn't quite the same, because in Leach, the court was talking about somebody who, as it were, consciously would want to say something and was impeded from saying so by some process that was put in place.
Yes, well,
Whereas this is not somebody who, by definition, wants to say something but feels there's something stopping them. It's the other way round. It's the lawyers saying, unless we meet and establish trust and rapport or whatever, we won't be able to draw out from the person.
I think it applies both ways round. When we look at what Dr. Cohen is talking about, a person who's lost their liberty, who's facing return to a country in which they may be in danger, may well want to come forward to express why it is they can't return to that country.
But does the responsibility, does the common law right extend to creating the circumstance in which somebody wishes to open up and they wouldn't otherwise do so? I mean,
So,
I'm not diminishing the difficulties, but do you have to create, and is the obligation to create an environment, put it more generally, in which somebody would want to disclose information rather than, because that's that's quite an extensive common law right.
No, because as with every posit that's been put to me as to whether the common law creates a positive right, my answer is always that I do not need to posit it that way because of the nature of the test that I need to satisfy, which is, did the arrangements, or in the prison cases, the rules, create a real risk of an impediment to the free flow of communication, I don't need to then posit an anterior positive right to circumstances that facilitate that. That's not an integral or necessary part of the way my argument needs to proceed to succeed.
So everybody has a common law right to be put. Is this right? To be put into a position in which they can make the fullest and frankest disclosure to their legal advisors.
Well, I've tried to put it in terms that's already established through Leach, which is the right of the free flow of communication between solicitor and client.
But again, without reading the statute, Leach was a case where the argument, and I'm looking at the top of page 53 in the bundle, but it's a solicitor, the postulate is a prisoner who wishes to communicate but is disincentivized from doing so by something that is done.
Yeah.
In other words, you have somebody who starts in the proposition, I want to tell you, my lawyer, something, and something is done that makes it disincentivizes him from doing so. So the free flow is impeded. Your situation is a next step on. It's not a client who has reached the point of wanting to say something, but is inhibited by something from doing so. Is it?
I don't accept that for the reasons I've just given. That a client may well want to explain the experience of sexual violence, which is the reason that they want to resist being returned to their country, but are inhibited from doing so by the arrangements in situ, because, as we know for this cohort, conditions of rapport are required. Can I say one more point just on before it goes out of my mind, which is that if one looks at unison, what you have there is the fees are imposed, and that inhibits, it shows on the statistics that were at issue there, around 10% fewer people were applying to the tribunal as a result of the fees. But they didn't have to demonstrate they had a right to a free tribunal hearing as a positive right, as a prerequisite to that argument. You don't have to always turn around the negative right not to be subjected to an impediment to your right of access to justice into a positive right to have something on which it's contingent. So, just to very quickly then summarise that submission, and I'll come on to the anxious scrutiny points. So we've got false imprisonment is detention plus no authorisation, burden of proof on the respondent to demonstrate authorisation. Respondent points to paragraph 18. Within the structure of the respondent's argument, it's clear that's accepted to be the four corners of that power are accepted to exclude any detention which abrogates the right of access to justice. We therefore have to look at what access to justice involves in this context. I say that's the any impediment to the free flow of communication, any real risk to the impediment of the free, any real risk of an impediment to the free flow of communication between a solicitor and client is such an infringement. Paragraph 18, therefore, does not authorise detention in circumstances or under arrangements which thus impede, and therefore the detention under those circumstances of this claimant, and indeed everybody under those arrangements, was outside the bounds of that power, was ultra vires, and not authorised, and therefore was a false imprisonment, because prima facie every detention is unlawful unless authorised. Actually, before I go on to anxious scrutiny, I pick up a point that was just raised in argument, and we can understand that by looking at Lumber because this goes to the remedies point that we were just talking about. So if my lords and my lady want to return to lumber, so in lumber, the situation there was that between a period of 2006 and 2008, foreign national prisoners, instead of being released at the end of their custodial sentences, were continuing to be detained by the Secretary of State. And the Secretary of State adopted an unpublished, i.e. secret policy, on a blanket basis that no foreign national prisoners would be released. And so that was held to be an unlawful policy because it wasn't published and because it was blanket. And that was held by Lord Dyson to infect the authorisation for the detention. So in that case, although there was a power on the face of the statute to detain them, the exercise of that power was vitiated by a material public law error. That's the phrase that he uses. So in that case, the court found that Mr. Lumber was falsely imprisoned, and so found.
Can we just give us the paragraphs that you've got to pick up?
So so it's the head note, and then we went to, I think it was, actually don't, yes, so that analysis I've just summarised is at 60 to 65, and in particular I took the court yesterday to the reference to Hague at 65, and then we can see at 161 is Lord Dyson's conclusion. Sorry, 169 is the overall conclusion on the last page of the extract we've given. For the reasons that I've given, the Secretary of State is liable to both appellants in the tort of false imprisonment on the narrow ground that she unlawfully exercised the statutory power to detain them pending deportation because she applied an unpublished policy which was inconsistent with her published policy. The appellants are, however, only entitled to nominal damages because if the Secretary of State had acted lawfully and applied her published policy, it's inevitable that both appellants would have been detained.
Let me confess that I have always found lumber extremely difficult. What do you say we should draw from paragraph 169?
So that's the conclusion. So again, in lumber, as here, no one disputed detention. The question was there authority for detention? The challenge to the exercise of authority there was a general challenge. The Secretary of State had in place for a 2-year period a policy that was unlawful, that influenced her decisions about whether to detain. In fact, the evidence was more than 2,000 people. So it was nothing bespoke about Mr. Lumber's detention. He was just subject to the same policy as all the other 2,000 FNPs. Mm-hmm. So that's why it's helpful to understand the structural context of the claim here, about which the court was expressing in the sort of remedies discussion with my learned friend some reservation, because Lumber shows that you can have a structural objection. It applied no different to Lumber than to anyone else. Similarly here, the arrangements and the unlawfulness by which I say that imposed upon the exercise of the powers of detention, or extended to, by which the detention was outside the powers available, applied just as much to SPM as to everybody else. But by reason of that, SPM's detention was, on this ground, unlawful because of that structural approach. And I'm just showing that that's not an unorthodox argument given Lumber. It's an argument that is accepted at the Supreme Court level, in its structure, of course.
Okay.
But it would only justify the declaration in relation to your client.
Well, that I would submit is a separate question, that the court can make more wide-ranging relief. I don't think that was sought in Lumber, that there was a more wide-ranging declaration, so it wasn't made in Lumber, so it's not authority for my A and B declarations. So, but nor is it authority against my A and B.
No.
But we put it A and B as a way of structuring why you get to C and D. Because for this ground, of course, she's got other grounds that for detention, but for this ground, she can't get to D on the basis of my argument without acknowledgement that the rest of the structural argument falls into place. So the court may not want to make the declarations, but it needs to go down that line of reasoning to get to my D in her case. And that's implicit within Lumber. The court had to accept that the policy as a whole was structurally unlawful in order to get to the point that Lumber was unlawfully detained. So it didn't make a specific declaration to that extent, but it certainly accepted the steps along the way. And what Lumber then left open was, in Lumber's case, his detention was said to be inevitable, so he only got nominal damages of £1, but it left open for all the other foreign national prisoners if their detention was not inevitable.
It was said it would be inevitable if she had acted lawfully, if the Secretary of State had acted lawfully.
That's what the Lord Dyson found in Lumber.
And
so
that's the counterfactual in Lumber.
Yeah, so causation goes to the question of damage rather than to the question of the tort, of liability for the tort.
So have I correctly understood the submission? I've noted down the policy, the unlawful policy, applied widely, but specifically to detain the appellants. So each of them was a specific victim, if you like, of the unlawful policy, who recovered only nominal damages because they could have been legitimately detained in any event.
Yes, it's not my submission. That's an accurate summary of Lumber.
And the point that you're making is that this is an example of a widespread error being relied upon as it affected individuals.
Exactly, my lord, yes. So I've taken back to that because there was some discussion about remedies in.
Okay.
So
yeah, I got it.
The point about whether the client had, the claimant who is clearly not brought this in any formal representative capacity, had to do so in order to establish the wider failings. But in my submission, she can rely on the wider failings in order to establish her own false imprisonment, just as Mr. Lumber could.
Thank you.
The next point I was going to address then is the anxious scrutiny and Juliet Cohen, Dr. Cohen points. I won't go back, but we've got the Carnworth test that was just examined an hour ago in the MN. My learned friend rightly doesn't dispute that this is a fundamental rights context that we're dealing with. It's a common law right of access to justice, but I would just add that the access to justice right at issue here was to facilitate proceedings which engage almost all the other fundamental rights, so the right to liberty, whether they detained unlawfully or not, the right not to be removed in breach of the right to life under Article 2, in breach of the prohibition on forced labour under Article 4, etc. So this is a context where clearly we're in a fundamental rights sphere. Turning then to the question of the judgment, one question I would invite the court to ask itself is, what is the basis that Mrs. Justice Lang expresses for having rejected the submissions of the claimant below, in respect of the evidence, both expert and factual, which was unchallenged by any other evidence, as to the remote-only access to lawyers issue. So if the court asks itself what was Mrs. Justice Lang's basis for rejecting the case advanced in reliance on that evidence, in my submission, trying to answer that, the court draws a blank. And that demonstrates the failure to give sufficient reasons to allow the court or any objective reader to understand the judgment below. Next point, similarly, this could be understood in terms of para 244 of MN as a failure to properly take into account the factors in favour of the appellant's case. That's all I need to say on anxious scrutiny. I come to the points about Dr. Cohen and paragraph 19. My learned friend took me to paragraph 19 of her evidence. What Dr. Cohen does in response to the questions answered is to rely on her own extensive experience of both research and, in her case, in fact, of going into detention centres for the purposes of producing medico-legal reports in hundreds of instances as to the acceptability of remote-only appointments. And if one looks at her CV, we see that that's not just a personal experience, but indeed something on which she's written academically. Her reports at 271 of the supplementary bundle. I'll just pick up some of her CV there.
271.
271 is where it starts. I think the CV's at the end from the collection. Yeah, so if we just go to 289, where she lists some of her membership of professional organisations and then her relevant publications. And then going to 290, she's written specifically at 14 about remote medico-legal assessment by telephone during COVID-19, monitoring safety and quality when documenting evidence of torture for UK asylum applicants. So it's a subject on which she's actually written an academic paper. So what she's doing in paragraph 19 is very properly saying that in terms of the nature of a legal visit, but as for communication as between lawyer and client, that strictly speaking is outside my experience. But she says the problems identified above for remote medical assessments, which are her field of expertise, would be equally relevant to any other assessment, including remote legal assessments, which cover much the same material and would face the same difficulties and limitations, with some people clinically unsuited to and at risk from the process of and the information obtained highly likely to be partial and incomplete. That's, while acknowledging not within her expertise, hardly a stretch to imagine that a medico-legal appointment at which she speaks with the very same client group to ascertain histories of torture and trauma would be comparable to the functions of a solicitor at a similar meeting for them. So, in my submission, that's an entirely appropriate way of phrasing her assumptions, strictly beyond her expertise, but one which this court can readily draw from her evidence. And given that, it is difficult to see the basis on which Mrs. Justice Lang below rejected those conclusions and indeed the rest of the evidence before her. The respondent has nowhere in any pleaded case up to today ever sought to take issue with the evidence of Dr. Cohen. You won't find it in any of the written pleadings. The respondent, I accept, submitted that the evidence as a whole did not show a real risk of denial of access to justice. But that was below, but it did not mount a challenge to independent components of the evidence, such as Dr. Cohen's. And that's because the argument below was focused on whether, because of Section 27, there was no denial of access to justice, i.e. it was legitimate to provide telephone only because it was authorised. See that, for example, in the tab 13, page 143. That's just the reply to the reply.
So Sorry, can you give me that again?
tab 13, 143. Because we ran out of time, I was asked to put in a written reply. And my learned friend then put in a reply to my written reply. And you can see within there the way in which that argument, as an example, was put.
Sorry, is that in the core or the
Core bundle, tab 15, sorry. So then come to section 27, unless the court needs time to that. Section 27 argument. In my submission, the simple point here is that that whole argument, once you understand the proper sequence, as I've already set out, falls away because it depends on a misalignment or a misunderstanding of the way in which the court needs to decide the false imprisonment question. That's the first point. I've argued in the skeleton argument a second point as to the suggestion that the generalised power under LASPO is authorising the arrangements in question. Quite simply, if one looks at that, it's a power that the Lord Chancellor may provide legal aid by telephone. There's no suggestion that that power is not subject to the limits of rights of access to justice itself. So the fact that the Chancellor may provide legal services by telephone does not abrogate the right of access to justice where legal assistance otherwise than by telephone is required. You can't say, well, I'm only allowed to dial into court when I represent a legally aided party because section 27 says may provide by telephone. So I don't really see how that can be relied on as the kind of explicit confrontation with an abrogation of the right of access to justice that the authorities contemplate would be necessary under the ex parte Sims legality principle. And then I just turn to three of the respondents' straw men or red herring type arguments, which have not been pursued with great gusto orally, but appear certainly in the written skeleton, so I just want to address those. There are three principal points that arise from the written argument. The first is the claim must fail because there's no common law right to legal aid. The second is the true challenge here is to LASPO 2012, and the third is that the appellant's case is that all detainees must have in-person legal meetings. The common law right point.
I'm not sure that these were developed, and
They were not developed.
Been there. So, in the context of reply,
2 is there, isn't it? 2 is there, isn't it?
2 soon. Okay.
Challenge to LASPO.
Okay.
In which case, my lords, I don't need to elaborate, since I agree they were not. They're all in the written argument, but were not pursued orally. So, unless the court has any intention of.
Well, my lady is saying that they've not been abandoned. My lady is saying that the second was the subject to written submissions of all submissions.
Oral submissions.
The first was
Oral
certainly
submissions.
qualified because I expressly mentioned that we'd gone a bit further in the skeleton than we needed to. That was the question of not asking the court to say there's no common law right ever to legal aid, which I think we discussed.
Okay. All right.
The
Oh.
I may have been being too picky. Take your course.
I'll be quick. It's true to say that the arguments about the legal aid. My learned friend didn't even turn up the ex parte Duncan and Whittam cases on which that was developed in writing. But neither of those authorities are nearly as broad as my learned friend would need them to be to support the argument, and that's apparent from the authorities themselves. Duncan is about rights to choose a legal representative. Whittam involves an obiter comment by Mr. Justice Laws, falling far short of any comment that there's no general right to legal aid. So neither of those supports the argument. On the second point, is the challenge should have been to LASPO. I've just addressed that actually, so I don't need to go over that again. And the third point was requires all detainees to have face-to-face legal advice. That's never been the appellant's argument. That's all I need to say on that. Lords, I suspect that draws me to the end of my reply. And if I may just take one look behind me, and unless my lords and my ladies have any further issues.
Can I go to sequencing question?
Yes, you may.
And I'm afraid it may come out rather ill-sequenced in its formulation because I'm struggling. As I understand it, you say that the correct sequence of the argument should be, this case is about whether somebody was unlawfully detained. There is no debate that somebody was detained. The question is whether there was lawful authority for it.
Yes.
And you say that the only lawful authority that the Secretary of State points to is paragraph 18 of Schedule 2 to the Immigration Act.
Yes.
And you say that must be read subject to, by implication, a limit that it cannot interfere with somebody's fundamental human rights, of which the one we are currently talking about is the common law right not to have your not to have the free transmission of communications with your lawyer interfered with. The actual wording I did write down somewhere.
Yeah, free flow, I think was the wording.
Free flow
from
of
Leach. Yep.
Free flow of communication between a solicitor and a client. And you said and I think it was implicit in what you said, which is that you say the burden is on the Secretary of State to show that that isn't what Section 8, the detention was doing in this case.
Well, the burden is on the Secretary of State to show that there is authority for the detention.
And if they say it's paragraph 18, do you have to say, yes, but paragraph 18 must be read subject to?
Well, Lumber doesn't deal with actually where the burden of proof falls when you're asking about...
In a sense, it's not a burden of proof because it's a question of what is... It comes back to, I think, what is the common law right which is said to be interfered with, or to be inhibited in this case.
So leaving aside burdens of proof, what the court needs to be satisfied of is what is the scope of paragraph 18. Is it within the four corners, within the ambit of that power, that people could be detained under the arrangements that pertained at Derwent's, or were the arrangements outside of that scope? And that will depend upon whether those arrangements impeded the free flow of communication.
And you say what was impeded is the free flow of information. That there was a real risk of a impediment to the free flow of information between some of the detainees and their solicitors. Because the only solicitors they were offered, and this is where it begins to...
So no, not because of the DDAS. So as I've always maintained, whether it's a privately funded solicitor, so someone may have a husband or a partner who's willing to pay, or they themselves may have resources, whether it's a pre-existing legal aid solicitor who's been helping them at the moment they're detained already, whether it's someone they find through a charity, as in SPM's case.
Right, but let's take these in
Whatever it is,
sequence.
yeah.
If it's a privately funded lawyer previously retained, why did the arrangements at
So in all of those,
Derwent inhibit? Because the lawyer could go and see them.
yeah. So in all of those cases, the arrangements have a chilling effect, because in all of those cases, the location of Derwent side is, we know on the basis of Dr. Wilding's expert evidence, a long way away from where immigration solicitors, private or legal aid, are located. So,
but the immigration solicitor, but the reason that the privately funded immigration solicitor doesn't want to go there can't have anything to do with the distance, because a privately funded a privately funded solicitor would simply bill the client for travelling.
yeah, so it makes it less affordable for the client. So it's less of a direct impact, but it's obviously a chilling effect. There may be some clients who could afford a solicitor to pop up from London for an hour, who can't afford to spend the money on accommodating them in a hotel overnight, etc. So there's still an impact, even on the private client, of locating the place very remotely from where their solicitor is likely to be coming. But that's likely to be a very small number of those detained. What one looks at is the whole picture, but I appreciate you're taking it stage by stage. But even in the private paying client context, there's a chilling impact of it.
You see, it's not really on the free flow of I struggle to describe that as a chilling effect on the free flow of information. It sounds much more like it's just more expensive. It's a funding question.
So to come back to the test, the overarching test, is there a real risk of impeding the free flow of communication? If the private paying detainee, few and far between as they may be, has the funds for a private solicitor to come to Derwent side and meet her there in person, then in that instance, the real risk will not have eventuated. Of course, that's...
Well, there's no real... I mean, I just struggle to see that there's a real risk in the real world. If you can privately fund your lawyer,
yeah.
Your lawyer must be assumed to be somebody expert in this field who knows that it's important to go and see the client face to face, knows that they won't be stopped from doing so, and they will go.
But the court needs to look at the whole picture, the whole cohort.
Oh yeah,
so
but I'm
private paying.
Okay, but sorry, a few moments ago you.
So what I'm saying is there may even be private clients, some of whom, well, I can't afford to pay the extra £300 to put you up in a hotel and pay your train up here from London. So that may even apply, even for the private paying client.
So this has nothing to do with legal aid at all.
It's to do with the whole
It's nothing
picture,
to
as
do with
I've
legal aid
maintained.
at all.
I've maintained all the way through my
Your submission now is that you cannot have an IRC at Derwent side, because even if legal aid contracts provided for the funding, so that legally aided people were adequately catered for, there might be some private client people in there who would have a chilling effect because they couldn't get their private lawyers to come.
No, because then you
this is not real world, is it?
No, because you're not then, with respect, my lord, looking at the real world. Because if everyone under legal aid was able to access the legal aid lawyer, I couldn't get to the point of a real world risk of impediment to the right of access to free flow of communication through face-to-face visits.
Say that again.
So
I missed that.
if the whole out of the 200 odd people we know were detained in this 6-month period, we know it was 166 in the first 3 months and presumably some more afterwards. The overwhelming majority of those, we well know, were serviced by legal aid. We know there were 6 visits. It may well be that some of those were the private paying clients. It's statistically insignificant to the question of real risk. If, on the other hand, 99% who are legally aided were all seeing, and the only people were the private paying clients, and the only one group of those were the ones who were unable to pay because of the location, it would be a much different case, wouldn't it? To say, is there a real risk in the real world of of these arrangements having impeded.
Well, at the
access to
extremes of
justice.
numbers, you may be right.
Yeah, but on a structural
But
level,
if you
that's
look
the
at
nature
if you
of
look at the
case.
principle of the argument that you're addressing, your argument a minute ago, as I understood what you were saying to my lord, was that this chilling effect, because it's at Derwentside, 15 miles from Durham and 15 miles from Newcastle, means that even for privately playing clients about whom we know nothing, there would be a chilling effect because of the additional expense of getting an immigration lawyer there compared to being in Hounslow or Fenchurch Street or wherever it may be.
Yeah.
And so your argument would be exactly the same. Detention at, and it's basically now, detention at Derwentside is unlawful because it's not in Hounslow.
That is not the argument, and
It comes to it, doesn't
it does not come to that, because what I'm talking about, my lord was saying, I want to break it down into the four components you've identified: private playing clients, those on full legal aid representation, those identified, let's say, by a charity, and those by DDAS. And what my lord wants to do is to look at each component. We got as far as the private paying clients. What the court needs to do is to look at the structural situation. Take, for example, Unison. The court looks at the broad spectrum of situations in which people were obstructed. Now, in Unison, 90% of people were not put off on the statistics from bringing their claims, but the real risk was identified by virtue of the 10% statistical situation. So, a factor in assessing whether there's a real risk is that these arrangements impact potentially even on the private client. Maybe it doesn't, on the millionaire client, it doesn't have an impact. But the real risk of impact is not limited to those who are on legal aid. It may also extend to people in other situations. So as the structural case goes, that's what the court needs to examine. It's the full picture of those detained.
Thank you. You got as far as private clients. Did you want to go beyond that?
I don't want to, unless my lord wants me to go through each subcategory.
But then
I
the
think
sec-
I've made clear that one looks at the full spectrum and not just at
Okay,
DDAS
so
and not just at
if we ignore private clients for a second, because obviously that was a little tributary I didn't expect quite to go down in the way that I did. It was driven by the way you put it to me. If we do talk about the detainees who are on some form of legal aid, whether it's a DDAS visit or a pre-existing visit.
Yes.
The free flow of information that is said to be the fundamental right, you say extends to being put into a position in which they are more likely to communicate an important fact to their lawyer. Because I think the important fact is that they may have been abused in the past or trafficked, which was relevant to whether they should be removed or not.
Or detained.
Yeah, or detained pending removal. Because I think the point is yes, I mean, it's relevant to removal, isn't it?
So it's relevant to both, because
but they
you're
wouldn't be
a very
detained if they
vulnerable
weren't going to be
person or not.
removed. They wouldn't be detained if they weren't going to be removed. So, yeah.
True, but you could challenge your detention irrespective of the question of liability to removal on the basis of too vulnerable to be detained.
Right. Okay. So you say that the common law right extends to affirmatively being put into a position in which you are more likely as a client to make that revelation or disclosure. Is that the way it is?
The common law right is more broadly textured than that specific component of it. The common law right I identify through Leach is to the free flow of communication between solicitor and client. The negative prohibition that I say the right of access to justice implies is that, as for example in all the prison cases, the Secretary of State must not, but in a negative way, impede the free flow of communication between solicitor and client. And so, but in that negative sense, when conditions or arrangements are put in place which impede the ability of those detained to communicate in a free flow with their solicitor, that is an infringement of that subcategory of the right of access to justice. On the evidence, we then turn to the arrangements by which the detainees were detained, such that it was extremely unlikely that they would get a in-person visit or visits from their solicitor, were such as to create a real risk of impediment to that exercise of the right of free flow of communication. That's the way I articulate it.
I mean, because the evidence was that some people never reveal it. And some people may take lots of time to build up rapport, etc., etc. So, before they are prepared to reveal their experiences. How do you say it's the wrong question to ask, to say how long does the Secretary of State have to permit in-person, how many in-person visits, how long, how frequently, all the time, you know, until somebody is prepared to say something? I mean, where does it, how does it stop? I mean, well, you saying the Secretary of State can never create a situation in which there is any restriction on in-person visits?
Well, the baseline that I've taken is that it is the translocation of this population from Yarl's Wood near London to Derwentside. So at Yarl's Wood, under the legal aid arrangements available, in theory there are limitless opportunities to revisit your client subject to reasonableness, etc. So it's down to questions of judgment and justification in each individual case, how many visits are needed.
Which sort of, right. But again, that sounds more like a sort of legal aid restriction.
Well, we addressed this yesterday with looking at this question of, in fact, it was my lady's question raised this point about those who may require 2 or 3 legal visits. And my point was that actually exhibits a greater degree of impediment to an instance where these arrangements led to a greater degree of impediment, because if it took 2 or 3 visits for somebody, so the solicitor goes, gets an inkling that there's something going on, but needs to come back after building the rapport and so on, these arrangements that make it very difficult to travel, that impediment multiplies if there's a need to travel twice or 3 times. So actually in those cases where disclosure takes more than 1 visit, an a fortiori example of how the inhibitions, the impediments it imposes on access to in-person or face-to-face legal assistance impede their rights of access to justice.
But it does presuppose that somebody is prepared to fund an in-person visit, or a sequence of in-person visits, or that there's a right, common law right, for this category of people to have a funded series of in-person visits.
Well, we keep coming back to the same structure of question of, do I have to rely on a positive right? And I have answered that specific question several times, as well as all the other
your
positive
positive
rights,
right presupposes that there is a flow, which you say can't be interfered with. And I suppose ultimately what I'm saying is your right seems to be to have everything in place to be provided with the circumstances in which the flow starts.
But my private client example works the same way. That the private client, if they need 3 visits in order to disclose, is still less able to facilitate the disclosure by virtue of the 3 visits now being 3 times, whatever, a multiple more expensive by virtue of the impediment that the translocation to a more remote location from, as our evidence shows, where all the immigration advisors in the UK are located. So there's still, even on the private client example, a problem. So it's not dependent on there being a right to funding, because one then comes back to my point that one looks at the whole picture. Is there a real risk looking at the whole picture? Is there that at least for some of this vulnerable group, these arrangements will impede their right of free flow of communication?
I don't know if I've thrashed that far enough.
Yeah.
Sorry, I don't think so anymore.
No. Thank you very much indeed.
I'm very grateful.
It will come as no surprise to you to know that we will reserve our judgment. You will get a draft in the normal way, subject to the normal restrictions for typos and obvious errors, but not re-arguing. We would be grateful if, when you get the draft, you would liaise and try at any rate to agree an order, although given some of the discussions we've had today, it's possible that there may be some consequential matters that need more than just your agreement in advance. But should that eventuate, then directions can be given, or there will be liaison with the court about how we're going to take these matters forward. Can I thank not only those in the front row, but those in the second row and beyond, who have obviously worked hard on this case and left us with plenty to do. Thank you very much.